Morning, everyone. Hello, Mike Kako. This is the June 21st, 2023 Land Use Commission meeting. This is an in-person meeting which is being held at the Hilo Hawaiian Hotel, Mala Ikena Room at 71 Banyan Drive, Hilo, Hawaii, 96720. This meeting is open to the public. Court reporting transcriptions are being done from a Zoom recording of this meeting. For all meeting participants, I'd like to stress the importance of speaking slowly, clearly, and directly into your microphone and turning on the yellow and the lights up on your microphone before you speak. And when you speak each time, please state your name and identify yourself for the record. Even though this is an in-person meeting, please be aware that all meeting participants are being recorded on the digital record of this Zoom meeting. And your continued participation is your implied consent to be part of the public record of this event. If you do not wish to be part of the public record, you should exit the meeting at this time. I'd also like to share that we will be taking breaks from time to time, approximately every hour as we proceed through the morning. And then we'll take a lunch break if we're still in session around midday. My name is Dan Giovanni. I have the pleasure to serve as the LUC chair, and we currently have 9 seated commissioners. And along with me, we have Commissioner Nancy Cabral from Hilo. I understand this is your last of 8 years. Is that right?
Tomorrow. Yes.
Tomorrow's meeting. I mean, today and tomorrow. So we're happy to have you here today. Commissioner Lee Hogigashi is ill today. He's from Maui and he's excused. Also here in attendance is Gary Okuda, Mel Kahele, Kuike Kamakea Ohelo, and George Atta and Brian Lee representing from Oahu. And Commissioner Michael Yamane is from Kauai. Also in attendance is the LUC Executive Director, Daniel Orendanker, LUC Chief Planner, Scott Derrickson, LUC Staff Planner, Riley Hakoda, LUC Staff Planner, Martina Segura, LUC Chief Clerk, Ariana Kwan, and at my left, LUC Attorney General, Julie Chena. Our first order of business is the adoption of minutes from our meeting of June 7th, 2023. Ms. Kwan, has there been any written testimony submitted on the June 7th, 2023 minutes?
No, Mr. Chair.
Thank you, Ms. Kwan. Are there any members, Ms. Kwan, are there any members of the public who have signed up to testify on the adoption of the June 7th, 2023 meeting?
No, Mr. Chair.
Thank you again, Ms. Kwan. Commissioners, are there any corrections or comments on the minutes? If not, is there a motion to adopt the minutes?
Use the microphone.
And for the record, is Commissioner Lee speaking?
Sorry, there was this is Commissioner Lee. There is, I believe, a typo in the draft minutes. I'm trying to find it, unfortunately, right now. But there was one sentence that talked about Corporation Counsel, page 3, I'm sorry, second paragraph, first sentence. Should be Deputy Corporation Counsel, COUNSEL, I believe.
Should be what? Again.
COUNSEL.
Oh, on council.
3,
Got it.
yeah.
Okay. Any other corrections or additions to the minutes? So subject to that one change, do I have a motion to adopt the minutes? Moved by Commissioner Atta. Do I have a second? Second by Koike. So all in favor signify by saying aye. Any opposed? None. So the motion is adopted. The minutes are adopted. Thank you. Next order of business is the next agenda item is the tentative meeting schedule, which will be shared with us by Mr. Orendanker.
Thank you, Mr. Chair. Tomorrow, we will again be here in this room for the AO2 737 Bencorp status report. Bencorp is also known as University of Nations. July is currently open. We will be in touch with the commissioners what we believe we can release those dates. August 23rd will be on Maui for the AO 7773A ELC status report.
1 second.
August moved to October.
That's- Okay, well.
1 second.
Okay.
One person talking at a time here.
Yeah,
Did you put this in front of me?
I didn't put that. It's an old one. That's a new one. There you go.
Thank you.
August.
Excuse me, Chair. August is currently open. September, we will be on at the HCPO conference at the Sheraton Waikiki from September 6th to September 8th. On September 20th, we are tentatively scheduling the Hawai'i development matter. We originally had Waimanalo Gulch scheduled for September 21st, but our belief is that that will move to October or November. On October 4th, we will be meeting on Maui for the AO 773 ELC status report, as well as AO 7773B WDVD status report, WDV status report. That's scheduled for both the 4th and the 5th. And that brings us to November. The staff and some of the commissioners may be attending the ULI fall meeting in Los Angeles from Monday, May 30th to Thursday, the 2nd,
November.
November,
What are the days for
30th to the 2nd,
December 2nd?
November,
November 30th to December 2nd.
October 30th. to November
October
2nd.
Okay, clear. So the ULI fall meeting is October,
30th to November 2nd.
that's in
And
Los Angeles?
yes, it is.
Okay.
And we expect, we're tentatively expecting the Waimanalo Gulch matter to be heard in December, either on the 6th or the 7th or the 20th and the 21st.
No. Okay, commissioners, do you have any further questions on the calendar? Hearing none, we'll proceed to our 4th order of business. It's a status and progress report on A19-807, the Kamehameha Schools, Sanford, QUARRY, Hawaii. This regards the status and progress report on the petitioner's environmental impact statement. At this point, I'd like parties to introduce themselves for the record. So representing the petitioner.
Morning, Chair, Commissioners, Township Chase for the petition.
Thank you, Mr. Chase. Chip Chase from OPSD.
Wilson Cotto, Deputy Attorney General for the Office of Planning and Sustainable Development. Thank you.
Thank you. And from the County of Hawaii. You got to push the button. Right where the light is.
Good morning,
Yeah, it's good.
Deputy Corporation Counsel Susanna Tiapula, representing the Planning Department.
Good morning, Chair and members, Zendo Curran, Planning Director.
Good morning, Chair and Commissioners. Jeff Darrow with the County of Hawaii Planning Department.
Thank you. Thank you all for being here today. Okay, Next, I'd like to go over the procedure for this portion of the hearing today. First, I will update the record. Next, I will ask the parties to identify themselves, which I've already done, so I'm taking that in a little bit different order. Then I will recognize written public testimony that may have been submitted in this matter, identifying the person and organization who has submitted the testimony. Next, I will call for members of the public who wish to testify on the ASBE's progress report. Each member of the public will have 2 minutes to provide their testimony and will stand by for questions by the parties or the commissioners. When all questions have been completed, the chair will excuse the witness and call the next. After completion of the public testimony portion of the proceedings, the chair would like the petitioner to provide his status report. The chair will then call on the county's planning commission and the Office of Planning and Sustainable Development for comments regarding the status report. Petitioner will then be allowed to respond to the comments that have been made by the county and OPSD. Commissioners will ask questions of the parties at the conclusion of each of their presentations. At the conclusion of the party's testimony and the commissioner's questions, the public will be given and granted a second opportunity to provide public testimony in the same manner that is set forth previously. Once that public testimony concludes, the commission will enter into deliberations regarding the status report and determine if any action will be taken. The chair will also note to the parties, as I had said earlier, that we will be taking short breaks from time to time, approximately 5 to 10 minutes every hour. Are there any questions by any of the parties regarding our procedure today? Hearing none, we'll proceed.
Chair.
Commissioner Okuda,
Mr. Chair, may I make a short disclosure?
just getting to that, so please.
Oh, sorry.
Please proceed.
Thank you. I'd like to disclose that I represent the ILWU Local 142 in a action involving Hawaii Island tours and respondent Edward Matsukawa. The respondent is represented by Kate Shetty Partners, Paul Saito, and Mauna Kea Trask of Kauai. I do not believe my representation of the ILWU Local 142 will affect any decision-making or evaluation I have in this case, but I would like to make that disclosure.
Thank you, Commissioner Okuda. Any objections from the parties?
No, Chair.
State,
No, Chair, thank you.
county,
No, Chair.
fellow commissioners, any objection? You may proceed. You do not need to just recuse yourself. Any other disclosures at this time?
Yeah.
Commissioner Cabral.
Yeah, thank you. I'd like to disclose that I know both Mr. Zendo Kern, Director, Planning Director, and Jeff Darrow, Deputy Director. Just in a professional manner, as I've worked with them over the many years of being here in Hawaii County, and appreciate their good service. Thank you.
Thank you, Commissioner Cabral. Parties, any objection to Commissioner Cabral continuing?
For the petitioner, no, Chair.
Thank you. State,
No objection.
county,
No objections,
Thank you.
Chair.
fellow commissioners? Hearing none. Thank you, Commissioner Cabral. Are there any further disclosures at this time from the commissioners? Hearing none, we'll proceed to public testimony. For the members of the public, again, please be reminded that the commission will not be considering the merits of this petition. Rather, the commission is interested in learning about the current state of the activities related to the docket, including compliance with conditions, and will consider whether action is necessary. I will recognize written public testimony submitted in this matter, identifying the person and organizations submitting the testimony. Ms. Kwan, has there been any written testimony submitted on this matter?
No, Mr. Chair.
And we're going to get you your own microphone, I understand, pretty soon, next meeting. Thank you. Next, I will call for members of the public who wish to testify on this agenda item. Ms. Kwan, are there anyone who has signed up?
No, Mr. Chair.
Thank you. So I see we have some visitors, but just to be sure, there's nobody that wants to testify. That's clear. Thank you. Okay, we'll now proceed to the status report to be presented by counsel for Kamehameha Schools. So Mr. Chip Chase, could you just give us an indication of the scope and duration of your presentation?
5 minutes, Chair.
5 minutes. Here we go. Thank you. Please proceed.
Thank you, Chair. Cal Chip Chase for the petitioner. Just to briefly orient the commissioners to this particular matter. The quarrying operations, the Sanford's quarrying operations has been in place for several decades under a conservation district use permit. Under the current conservation district rules, they cannot renew that permit. The subzone would need to change, and the Office of Conservation and Coastal Lands has previously taken the position that it would not be appropriate to change the subzone. They would not support that. And so in order to continue quarrying operations, we have asked or will ask when we get to that point for a district boundary amendment to agriculture to be followed by a special permit. So you will see a lot of us as this matter rolls on. The first step in that process is an environmental impact statement. And so we filed the petition for district boundary amendment, recognizing that the next step would be, the initial step really, would be the environmental impact statement. We asked the commission to be the accepting authority for that statement, and the commission agreed. From there, an environmental impact statement preparation notice was published, is actually published a little bit earlier than that, and comments have been received, including comments from state agencies. All of this happened toward the middle of 2019. Since then, as we all know, we entered into a pandemic, and that certainly slowed down the progress in preparing the environmental impact statement. Nonetheless, it has proceeded, and a couple of drafts have circulated between the licensee, Sanford's consultant, and Kamehameha Schools. And we've been able to comment on those drafts as we get closer to a point where we're ready to circulate publicly the draft environmental impact statement. At this point, for a variety of reasons, the licensee, Sanford's, is going to change environmental consultants to another firm that hasn't been selected yet. And so I can't publicly disclose what would be the likely new consultant. But I want the commission to understand and be assured that Kamehameha Schools and its licensee are committed to continuing with this district boundary amendment and continuing the quarrying operations at the site. The site is 94 acres. That would be the scope of the district boundary amendment. And we'll look forward to proceeding with the EIS phase, the environmental review phase, and then coming back before you for acceptance of that document. And from there, moving on to the district boundary amendment and ultimately the special permit. That's the status of the review. We continue to move things forward. I'm hoping now that we're through the pandemic, once the new consultant is in place, we'll move forward with good speed. I would estimate, though, it's probably another year before we're ready to publicly release the draft environmental impact statement, ensuring that all the appropriate studies and all the appropriate reviews have been conducted or updated as necessary. That concludes my presentation. I hope I made my 5 minutes, Chair, and I'm happy to answer any questions.
You did make your 5 minutes. Congratulations.
Thank you.
Yeah. So 1 year from now is when we'll see you expect we may see the draft EIS.
Yes, Chair.
Going forward, just general timing, I won't hold you to it, but what is your expectation for the next two major steps, which would be the DBA and the special use permit?
So my guess would be from the publication of the DEIS, we're 9 months-ish until you see us on a final. And then I would say you're probably another 9 months or so until you see us on a DBA. So if we put all those numbers together, I would say 2.5 years or so to complete those phases of the process.
So that'd be the start of the DBA?
Yes, Chair.
So then from there, the DBA process, and then we would go to a special use permit if the DBA is changed to agriculture.
That's correct, Chair.
So that's another
6 months easy.
Easy, yeah. So we're talking a process that is 3 to 4 years in total. You may be looking at a whole new set of commissioners by that point in time as well.
I would think some changes on the commission, Chair. I don't think Commissioner Cabral will still be here, for example.
Yeah. Okay. Thank you. Yeah, I'm going there. So commissioners, besides the questions that I just asked for clarification, any of you have any questions for the petitioner? Commissioner Okuda?
Thank you, Mr. Chair. Good to see you again, Mr. Chip Chase. Let me preface the basis for this question, even though I know you know the basis, but just in case there's audience in Zoom or otherwise. And I quote from the Kapa'akai versus Land Use Commission case, 94 Hawaii 31 at page 46. The Pacific Third citation is 7 Pacific Third 1068 at 1083, a 2001 Hawaii Supreme Court case. And the quotation is, quote, as such, state agencies such as the LUC may not act without independently considering the effect of their actions on Hawaiian tradition and practices, close quote. So that's the framing of my next question. I saw in the petition and the record that you filed a cultural impact analysis. Is there any intention of updating or supplementing that analysis?
Yeah. So if I may preface my response with a small comment. If I ever bet against you asking me a question, I would lose every time. The Kapa'akai analysis, of course, is important in any commission action and indeed other state actions. And so when the final environmental impact statement is accepted, hopefully by this commission down the line, it will include the most updated cultural impact assessment.
Well, is there anything in the impact analysis right now or anywhere in the record that indicates whether mining or partial or even full demolition of a cinder cone or a pu'u would affect the types of rights or traditions or practices which are required in Kapa'akai to be analyzed and protected?
Commissioner, I didn't go back and look at the assessment. My recollection from reviewing the DEIS drafts is that it is not anticipated that there are any ongoing cultural practices within the petition area that would be adversely affected.
Yeah, I think that's what the conclusion is. I think my more specific question is it true or not true that the continued or prospective cinder mining operation is intended to mine or carve into the existing cinder cone or pu'u?
It will carve into the existing land formations within the petition area. The purpose is to expand the mining operations to cover this 94 acres.
Okay, does the cultural impact analysis right now, or is there anything else in the record which indicates whether or not that, well, how you described it, you said formation, but cinder cone or pu'u has or has not any cultural significance? Because I might have missed it, but I didn't see anything in the record which indicates whether or not that cinder cone, pu'u, or formation, or however it's being described, has or has not any type of significant significance which is required to be evaluated and protected by the Kapa'akai case.
So with respect, I don't think that's what Kapa'akai requires. Kapa'akai looks at ongoing cultural practices in the area that may be adversely affected. And the purpose, of course, is PAC, in that PASH allows traditional and customary access until the land reaches a point of being fully developed, so less than fully developed land. When dealing with the district boundary amendment, you run the risk the land will be developed, therefore extinguishing the cultural practice, the PASH practice. And so it's important to analyze that potential impact under Kapa'akai at this earliest stage. We're not moving to an urban designation. The property won't be developed. Nonetheless, if there were ongoing cultural practices, they could be adversely affected. And so that's the lens through which a cultural impact assessment is done.
Okay, well,
Your question, if I just can wrap that up, about whether this particular cinder cone has any independent cultural significance apart from any ongoing cultural practices is a question I don't currently have an answer to. But I understand your concern, and I would assume that we could evaluate that as a part of the cultural impact assessment or otherwise the DEIS if that is appropriate. While I wouldn't venture to conduct or comment on how cultural impact assessments are conducted in detail, I know that a big component of that is meeting with members, cultural practitioners in the area and asking them whether they have any ongoing practices or aware of ongoing practices in the vicinity or the petition area. As part of that inquiry, it seems reasonable to ask whether this area has any independent cultural significance.
yeah, I'm not trying to get you to agree with my ultimate legal analysis or not. My question was just whether or not the record contained any facts, evidence, or information relevant to the question I asked about whether this is an important or whether we can look the other way. That's all I'm asking.
Understood. And I just want to provide context for the
Yeah,
answer.
okay, sure. And then my other question is arises either rightly or wrongly from what I read in the media about the criticism of the Public Utilities Commission in the whole Pili case of not, looking at the Land Use Commission requirement about utility lines. So my question is this, is your status title report that was presented as part of your moving papers included encumbrances against title identified as items number 7 and 11. And these apparently were covenants or conditions which the landowner granted or agreed with the Department of Land and Natural Resources. I didn't see, and I maybe overlooked it, and that's why I'm asking this question. I didn't notice anything in the record which spelled out exactly what these covenants or conditions were that were recorded against title. Would you know off that, and if you don't, no big deal, whether or not there's anything in the record which specifically spells out in detail what these covenants or conditions are? Might be, irrelevant to what we're doing, but it does appear on title, and it's covenants and conditions that were given to the Department of Land and Natural Resources.
No, Chair, or no, Commissioner. Offhand, I'm not sure which covenants and conditions those may be.
Oh, okay. It was just that if I'm still around when this thing comes up, I would not want to do anything or make a decision which would be contrary to, what the Department of Land and Natural Resources might have required or imposed regarding the property. Okay, thank you very much, Mr. Chip Chase.
Totally understand.
Thank you, Mr. Chair. No further question.
Thank you, Commissioner. Commissioner Otta.
Yeah, I noticed that the thing is the existing quarry, he's supposed to return it back to its original condition. And I was just wondering what the situation was that?
Original condition, there's certainly mitigation obligations or restoration obligations. It'd be difficult to put it back exactly like it was once you take rock out, of course. But in terms of restoration, that is a portion of the conditions associated with the permit. I don't have an answer for the current condition of it for you. The counsel for the licensee for Sanford's is here. And if that's something that you'd like her to address, I'm sure she can come up and do so.
Could you?
I'll have to swear the witness in. Please state your name, affiliation, please.
I'm from Carlton Ball. I'm the attorney for Sanford.
So I think you got out there. Can we have your name again?
Hello?
That's good.
Okay, I can't touch it.
Can't touch it.
Don't touch, don't touch. Okay, Catherine Garson from Carl Smith Ball. I'm an attorney. I represent Sanford Service Center, who is the licensee of the property.
Do you swear the testimony you're about to give today be the truth?
It's the truth.
Please proceed.
The question was about,
The status of the returning the condition back, mitigation is what.
yeah, so the condition is when they're complete with the quarry and they're still quarrying, so it's not restored. It's 6 months after, I think the condition is 6 months after the completion of the quarrying.
And then what happens to the land after that?
After it's restored?
Yeah, but right, you know, like Kamehameha schools have some plans for the land, or is it?
Back to me, Caltrip Chase for the petitioner. I'm not aware of any current plans that Kamehameha Schools would have for the current quarry area once operations conclude.
Yeah.
Other than restoration.
And that's an obligation on the licensee.
Mr. Otta, anything further? Mr. Okuda?
Thank you very much, Mr. Chair, since Ms. Garza is here. Ms. Garza, can I ask a question? Mr. Chip Chase gave an explanation of why the environmental impact statement or the chapter 343 assessment or evaluation hasn't been done. Can you identify the name of the environmental consultant that was working on it, who's now not working on the assessment? Or
Yes, it's Graham, not, it's GK Environmental. It's in the EISPN.
is there a reason why they are not going to continue with the project? Because it seems like the lack of an environmental impact statement is creating a significant or substantial delay.
Yeah, so the consultant is GK Environmental LLC, and nothing against them at all. At all. They're basically, it's more to do with sort of internal coordination and communication issues that I think is the issue. So when we get a new consultant on board, I think those will be resolved, and we can have, we're set. With our new consultant, we want to make sure that we keep the communication open, have regular meetings, make sure everybody's on the same page. And so I think moving forward, I think that would work better, but not pointing fingers at our consultant at all.
Yeah, no, I understand. You know, we all in practice, we get a consultant, might not work out for many reasons. Was there any disagreement regarding the potential substance of the environmental impact statement or environmental assessment or any chapter 343 issue which led to the change of environmental consultant?
No.
Okay, thank you very much. Thank you, Mr. Chair.
Thank you, Commissioner Okuda. Commissioners, anything further? Commissioner Cabral?
Yeah, am I clear that my understanding would be, or I would consider someone maybe common sense, that in the event the Sanford leasing in this event were to not restore the area as what, I don't know yet what's going to be required of that. Well, obviously there'll be a large hole there, and at some point you would need to do something so we don't leave it in that, manner. If they were, when does that get described as to what's going to be required? And if they were to not do it, would then Kamehameha Schools be required to fulfill that obligation?
So if I recall the terms of the conservation district use permit, it's 6 months after that the area needs to be restored, and there is a plan. We're required to present a plan about the restoration.
Okay, I won't be here when all that happens, but I am familiar with coal mining that's been done not in caves, but in areas where they just, in Wyoming, take out entire huge hillsides. The equipment used is massive. But they're required to return it so that every rolling hill looks identical. So they have to go other places and get, because they're not taking all of the dirt though, they just take part, but they have to bring back in enough substance and soil that the entire terrain is identical, planted with the same exact type of top layers of dirt, which they say when they take it apart, and the same grass is planted. So I'm interested in seeing what's expected here, because clearly we have other areas where you could bring cinders in from somewhere else and redo it. But I'm just saying, I don't know what the answer is. It's just an interesting question. Okay, and Kamehameha schools though would have to, in the event that Sanford does not comply, they would be required to comply then.
Township Chase again for the petitioner. Ultimately, Commissioner, the permit obligates the landowner.
Right, thank you very much.
Anything further, commissioners? Thank you. We'll proceed to the county for comment and presentation.
Good morning. Deputy Planning Director Jeffrey Darrow did file revised comments yesterday on this project. We have no additional comments, and we are willing to wait until a new consultant is hired.
Could Mr. Darrow provide a summary of his comments?
Yes.
Mr. Darrow, I need to
Sure.
state your name and affiliation for the record, then I'll swear you in.
Jeff Darrow, Deputy Planning Director for the County of Hawaii Planning Department.
Do you swear the testimony you're about to give is the truth?
I do.
Please proceed.
Thank you. In 2019, the county received the draft EISBN to provide comments. In January of 2020, the county planning department did respond with comments. At that particular time, the process that would have been available to the applicant in regards to a general plan amendment would have been that the applicant would submit. Since 2020, the planning department has initiated a comprehensive general plan amendment update. And during that particular time, until it's finished, no applicant or person or entity can submit a general plan amendment during that time. So we were just updating our comments in regards to that. We have also taken steps to meet with the applicant or the landowner and understand their request so that we can incorporate that in our general plan update. Thank you.
Thank you. Anything further from the county?
Nothing further.
Commissioners, any questions for the county? Petitioner, do you have any questions for the county?
No, Chair.
I don't need to do that, but I'll give you a chance to rebut anything at the end. OPSD, do you have any comments, please?
Allison Kato for OPSD. I just have one brief comment regarding the timing of the EIS. Petitioner mentioned that it will probably take about 2.5 years to complete it. I just want to clarify that the EIS will need to comply with the new EIS requirements that are currently in effect. Right now, it falls under the old rules, but if the FEIS is not accepted by the LUC by August 4th, 2024, 5 years after adoption, then it's going to need to comply with the new rules. That's all. Thank you.
I see a little confusion there on the dates. I want to make sure that the timeline that Mr. Chip Chase presented is consistent with your understanding from the state.
Chair Cal Chip Chase, my timeline included the DBA. So it's a little faster than I think 2.5 years were presented, but if we don't make the acceptance of the final environmental impact statement by the deadline set out in the rules, of course, we will comply with the new rules.
Okay, but your current prediction is you'll be done in time under the existing rules.
We hope so, Chair.
As Ms. Kato pointed out, if you don't meet that deadline for whatever reason, then the new rules, your position, Ms. Kato, is the new rules would go into effect.
Yes, sorry, I may have misunderstood the timeline.
Not at all. And we completely agree with Ms. Kato.
But yes, it is a tight deadline.
Okay. Commissioners, any questions further for Mr. Otto, Commissioner
Yeah.
Otto?
I just have a question. You know, as you close the existing quarry and you start the new quarry, there's a question that's in my mind that says, well, this commission hasn't in the past looked very much about, but what happens to the land after it's been used, and and that seems to be we haven't looked at that before. And that would, I think it's an important question. And then as you look at the new quarry extension, you would like to say, well, what are you going to do with the existing question? And it's kind of a thinking about what their idea of the land is. And so when it's no longer a quarry, what is it going to be after that? And so I was just wondering if there's something that KS looks at that, or if it's just left empty, sort of like.
I appreciate the question, Commissioner. And just to be clear, this would be, I wouldn't view it as an old quarry and a new quarry. I'd view it as an expansion of the quarry area to ensure there's sufficient material to meet the existing needs. In my experience, Commissioner, this commission has looked at the use of the land and the condition of the land after the closure of any quarrying operations. And so the SPs that I've been involved in that have involved quarrying do usually include, or have always included, and I guess would be clearer to say, conditions related to the condition of the property following the completion of the quarrying operations. And those conditions include the representations that the applicant has made, which typically include, as Ms. Garson said, with the existing CDUP, a plan for the restoration and the remediation of the area, as well as incorporating specific conditions related to the property once the SP has ended, once the quarrying operation has concluded. So I would say this commission has looked at those things, at least at the initial permitting stage, and has been involved in crafting and imposing those kinds of conditions, which I think are appropriate. In this matter, those conditions, of course, will be part of eventually, if we receive the approvals we need along the way, the SP that allows the quarrying operations on ag land if the DBA is ultimately approved. And I think, Commissioner, I think all the current commissioners and whoever is there at the time will be interested in the plan that the applicant develops for remediation and closure, and will be interested in imposing those conditions. From the landowner's perspective, this is our land, and Kamehameha Schools cares about its property today and at the conclusion of these operations. So we'll be very interested as well in ensuring that appropriate restoration and remediation conditions are imposed on our licensee.
And will the commission have the opportunity to review the future plans?
Yes, that will be part of the SP proceedings, Commissioner.
Okay.
Thank you.
Just clarification, Mr. Chip Chase, the existing quarry area, land area for the existing quarry that you expect to close, you do not expect, you expect to continue or expand that existing. So my question is, the DBA and subsequent SP will be for the area that is the existing quarry plus the expanded quarry.
Correct, Chair.
So the remediation plan would be at the end of the.
When operations end, Chair.
Yeah. Okay. Commissioners, anything further this time? Okay, Mr. Chip Chase, do you have any further comment or rebuttal from what you've heard? So,
Nothing, Chair.
Commissioners, do you have any final questions or comments for the parties? This is the final call or the second call for public testimony on this agenda item. Are there any members of the public who wish to testify on the status and progress report of Kamehameha Schools on A19807? Thank you. Now we'll have further discussion. Commissioners, this has been a status report and we're not required to take any specific action at this time. And if no action is taken, the requirement of continued annual status reports will remain in effect. Is there any further discussion or suggestion of actions to be taken by commissioners? So the chair will entertain a motion regarding how the commission should proceed on this matter. Including, for example, that we would just continue with the regular scheduled progress reports. I'm looking for some action and Commissioner Cabral is coming forward.
That's it. I would make a motion that we continue to receive our reports and look to take action once the environmental impact statement is prepared and all the information is available.
Thank you. Do I have a second to that motion?
Second.
Second by Commissioner Yamani. Any further comments or on the motion? The chair will be supporting this motion and in particular on your status reports, we'd be looking for updates on your forecast of major events that might occur over the next few years.
Understood, Chair.
Yeah, thank you. So all in favor of the motion, signify by saying aye.
Aye.
Any opposed? So be it. Motion is approved.
Thank you, commissioners.
Chair would like to take a short break of what time is it now? 10:47. We'll come back at 10:57 or we'll come back at 11 o'clock. So we plan to go in, as we're agendized, we'll go into executive session. What's that? Riley. So we're going into executive session and it'll be confidential discussions. So this will be limited to commissioners and Ms. Chena, representative of the Attorney General's office. And also, I think Commissioner Okuda, you wanted to be excused as well. Is that correct?
Yes, that's correct. I asked to be excused. You want me to give a short reason?
No need. We gave the reason last time and I'll do it on your staff.
Yeah.
So let me ask anybody that's not a commissioner and not Ms. Chena to excuse themselves from the room. Okay, we're back in regular session. It's 11:40. Commissioners, any further business today? Hearing none, this meeting is adjourned. And it's in recess, I should say, not adjourned, until tomorrow morning at what time, Ariana?
9 a.m.
9 a.m. tomorrow, back here, same room. Okay, see you then. Thank you.